Good morning, all. Myself, Manjunath R. So, I'm from the Patel Law College. I'm specialized in intellectual property rights and technology law. See, intellectual property rights is a kind today due to the booming of startups and also the technology era. So, IP plays a very important role. Under intellectual property, we used to protect different criterias. So, this is an intangible property. So, we can't easily find out, but IP plays a very important role. So before going to the intellectual property, I just want to give a hint related to the intellectual property. You may heard like patent, trademark, copyright, design, geographical indications. These are the part of intellectual property. These will come under the umbrella of IP. What exactly the IP? You see, IP is a kind of a intellectual one. So it's a creation of mind will be coming under the broad umbrella. So in that actually it includes designs, inventions, and also the creations, artistic work, musical things. So many things will be coming under that. So under that there are certain parts they have divided as patent, trademark, copyright, geographical indications like that. So in each part there will be a combinations and then it will be protected. So if you take the patent, so under the patent, the invention is protected. So in India, we have Indian Patent Act 1970. So before 1970, we had the previous act, Indian Patent and Design Act. It was bought by the colonial ruler. Then later 1970, they bought dedicated act to the patent. So under the Patent Act, we used to protect the invention which creates the product or process. So indirectly what it says is it gives complete provision related to the invention of product or invention of process. It protects and it also gives the protection and give the exclusive right to the inventor. The main objective of the Patent Act 1970 is to give the protect the inventor rights. So under Patent Act 1970, there is a section called Section 48. Under Section 48, it provides exclusive rights to a patentee. The patentee is a person who gets a patent on his name, or it can be an inventor, it can be applicant to the patent. So you are actually the beauty here is actually the main objective of the patent law or patent thing is so whoever create the invention, whoever does the invention, that person has to get a benefit for a certain period of time. So here actually what they will do, so under this act, this is a global thing, but the patent is a territorial law. So under this, what they will do is, so they will give the exclusive right for a 20 years. So in this 20 years, the patentee will be getting monopoly on his invention or his product, and he have all the rights like without his consent nobody can sell it, nobody can make it or use it or transport it, export it. So you will be getting exclusive right. If somebody does, then it will be he have the rights to sue in the court of law. So this is the patent thing. Another IP is under intellectual property. We have trademark and also we have copyright. So under the trademark, we have exclusive law in our India. Trademark Act 1999. So this trademark, under this trademark, so what exactly they want to protect is, so there are like different big companies are there. So their companies they used to provide goods and services. So the goods and services can be distinguished based on the trademark. Take an example of Reliance, take an example of Tata. So there are big companies. Those company we will identify by seeing their brand names. So these brand names are the like monetary to them to make the commercialization for their profit. So that's why under the trademark we have dedicated law. So in India, so there is a procedure for a trademark registration. As we have similarly, we have in like patent registration, there is a certain protocols and procedure will be there. So different forms will be there. In trademark also we have trademark registration and trademark process. So if you get in a say for example, you have come with a company or you have come with a like new idea, you want to start a startup. So you want to build a brand. To build a brand, first what you should do, you should register as a trademark. If you register as a trademark, then your brand will be protected for a certain years. It can be protected maximum of 10 years. So after that you can renew it and you can extend the production. So thing is actually you can protect your trademark for infinite years, infinite period. When we compare with the patent, the patent protection is for 20 years, but trademark protection is 10 years. After every 10 years we need to do the renewal. So once you get any trademark registration, so your brand will be protected. Nobody else can't use your brand name or brand logo without the permission of you. So indirectly, it will be beneficial to you, and also it will be like a recognized mark in the market. So this thing, and another intellectual property is copyright. So copyright is a law we have. This is one of the intellectual property. We have a dedicated law from 1957. In this, actually, we used to protect all the literary and artistic work. Taken at like if an author write a books, if somebody composes musics, if somebody creates the web series or dramatic things, then those person can protect their in like creations with the help of the Copyright Act 1957. So under this act, actually, so the creation of artistic work and literary works will be protected. So this will give the rights to a creator. But one condition is here is actually the originality has to be there. If it is original, if originality is lacking, then you can't protect the copyright. So once you get a copyright protection, so that will be protected for the life of an author plus 60 years in India. So indirectly, after your death also, it will be protected for 60 years, so that your family or legal representatives will be getting a benefit out of it. So this Copyright Act 1956 is also very important IP, intellectual property under the IPR. So then another we have Design Act 2000 and also Geographical Indication Act 1999. See, there are a lot of segregation, subdivide and subset under the intellectual property. When we compare these five things, one is patent, another is trademark, another is geographical indication, Copyright Act, and Design Act. Each has significance and different provisions. So coming back to the patent again, actually, because nowadays actually so many innovations are happening in the technological industries. So those innovation has to be protected, especially if you take a consideration in the pharma sector, because pharma sector plays a very important role in patent field, because every medicine is a kind of a new invention. So whatever the company, pharma company comes with a medicine, so that will be protected for certain duration and they will make a money out of it. So that rights and that invention can be protected under the patent. See, this patent thing is not like it's a universal thing. In every country, there will be a patent law, and also trademark law, copyright law will be there. In each country, based on their innovation ecosystem, they will be having these laws. So in India, actually, we have the patent law. There is also in the patent law, we have the patent rules. So patent at 1970, they have bought it. Along with that, we have the patent rules. These rules will be providing the regulations and also the procedure for the registration of a patent. See, if I am an inventor, say for example, I'm an inventor, I have invented something new, which is very new to the market, nobody knows. Then what I will do, I want to protect my invention. So if I want to protect my invention, so what I will do, I want to apply for a patent. I will go to the company which can protect my patent. So I will approach them. There the company will do certain basic things. So under the patent, what they will do actually, there are certain tests they will conduct before granting a patent, before filing an application for a patent. So the certain test we call as a Trinity test. Trinity test is first thing, if invention wants to protect under the patent law, or if you want to get in a patent, so it has to satisfy three tests. One thing is novelty, another thing is inventive step, another is industrial application. So this novelty, inventive step, and industrial application, these three tests we call as a Trinity test. So these three criteria it has to satisfy. If these three criteria satisfied, then only that further process for patent can be move on. If novelty is nothing but actually it has to be new, nowhere else in the world, not only in India, nowhere else in the world, your idea of invention should not be there. So your invention has to be first, it has to be a new from your side. If it is present any platform, even it is take as a YouTube platform or Instagram or any platform, if it is already that idea is existed, then it is not accepted. So novelty we will find through the help of the prior art search. So this is the methodology. We will with the help of the database, from the different database, we will find out the novelty. Then inventive step. Inventive step is nothing but it has to involve certain innovation in the it has to apply like we have in inventive step we used to consider like it has to be non-obvious. Non-obvious in the sense that general skilled person should not aware of it. So it should be non-obvious. If it is a non-obvious, then it will be considered as an inventive step. If it is obvious, everyone will be doing, then there will be no new novelty will be there. Then it won't be considered for an patent. Then another thing is in industrial application. So whatever the invention you do, okay, that has to be applicable to a industry. Because if your invention is not applicable, then what is the point of protecting it? What is the point of generating the money from it? So that's why these three criteria it has to be satisfied as per the patent law. In Indian Patent Act 1970, under the Section 3, so Section 3 and 4 talks about subject matter of patent. See, this Section 3 and 4 is a very, very important section under the patent law. The reason being is you will be getting to know what all are the invention which you cannot protect under the patent law. See, Section 3 has subsection A, B, C, D, F like that. In each subsections, there is a provision which clearly says, so if your invention comes under these provisions, then it is not eligible to get any patent. So that's why every inventor has to aware of it, whether your invention is comes under the Section 3 and Section 4. Section 4 is something related to the atomic energy thing. So your invention comes under the atomic energy thing. It can't be considered under the patent because in India we have separate act called Atomic Energy Act 1967. So that act deals with your all the matters related to the atomic energy. If you want to protect your patent, then it has to pass away from the subject matter of the Section 3. For example, take example under Section 3, there is a provision called, there are different provision. If your invention is connected with the abstract idea, is it just a theoretical thing? If it contains the mathematical formula, if it is not applicable, and also it is related to the horticulture and it is related to the plant varieties, it is related to the traditional knowledge, then those invention cannot be protected under the patent. Even if your invention is like linked to the discovery, for example, you have discovered something, so that discovery is not protected under the patent. So that broad idea about subject matter of your patent, it's even under the Section 3. Section 3 is a very, very essential provision before going through the filing for a patent. If your subject matter satisfied under the Section 3, if it is not comes under the Section 3 provision, then and also it satisfies the Trinity test of the patent, then it is eligible for a patent. So after that, if it is eligible, you can file for a patent as per the different forms. Under India, we have the patent rules. So under patent rules 2002 and 3 and 4. So under that schedule 2, there is a different forms will be there. There are totally 31 forms are there. So these forms we will be using for filing application, for filing infringement, for filing revocation, for filing grace period. So there are so many things we will be doing in patent related to the patent of protection. So in that forum number 1, forum number 2, 3, 4, 5, and also forum number 9. So we will be filing while filing for the registration. In India, the patent registration will be very like time-taking procedure. When we compare with like statistical data, when we take the statistical data from the Indian Patent Office, as per the statistical data from Indian Patent Office 2025, the presently in India, every say last 2025 and 24, almost 1.5 lakh patent application were filed actually. That was a huge, tremendous kind of successful for India because when we go back to the 1980, 1990, the application for patent was very limited. Now it has increased tremendously, more than lakhs actually. But once it is applied actually, the success ratio and the sense with the final grant of the patent is very limited. But so application for a patent is a different thing, but granting of patent, it will take around 2 to 3 years. Certain extent, it may take 4 years also. Here actually, once you applied for a patent, so you'll be getting a priority date. So priority date is a very important date. We call as a filing date and priority date. From that date only, we will be having the 20 years period. So once you get a priority date and after the grant of the patent, so your patent will be protected for 20 years. So after that, so it's tenure. So if anybody wants to object it, if anybody wants to object your email, like whatever the granted patent, so they can file an objection within the 12 months of your granted period. So this is the like provision. There are different procedural step manners are there actually, and also in the procedural you have to satisfy it. So once you get a patent, so you will be having the monopoly on your invention for a period of 20 years. So this is related to the patent which comes under the one of the IPR umbrella. So another thing is trademark. Compare it with a patent. Trademark purely talks about the marks. The marks we have different marks. Sound marks we have, image marks will be have, so like collective marks will be there. Different types of marks will be there. So these marks will be protected under the Trademark Act. But actually, this Trademark Act came in 1999. Before that, actually, many companies have started in India. Those marks are not registered. If they want to register, they can register. Even though if they didn't register, it is okay. But actually, sometimes what happens actually, take example of Raymonds. Raymonds has started very long back ago. So they have become the well-known marks. Under the trademark, some marks we call as a well-known marks. Even though they are not registered, but they will be protected under the trademark. So that's why there is a provision under the Trademark Act 1999 called Section 27. Under Section 27, we call as a passing of methodology. If this passing of comes for especially for the marks which are not registered, even though it is not registered, but they are protected under the trademark. So like under the Section 27 provision. So the main objective of the Trademark Act is to protect your identity. So identity is the brand name because that is also your creation. That is also your like commercialization of your invention or your mindset actually. So that is very essential. So this trademark in India actually is growing because reason being is from past 2 3 years startup ecosystem is building. Many startups are coming out. These startups are like filing for a trademark. So that's why the area of the trademark is a very essential, and now it has become booming compared to the patent. See, one thing you should segregate: the patent is completely deal with the invention thing, the trademark is completely deal with the marks thing actually. So brand identity. When this we compare with the copyright, actually, the Copyright Act talks clearly with respect to the artistic work. Artistic work can be literary things, as I told earlier on. So that will cover large range. For example, you take like for example any books or web series, so that will be protected, and also that protection will be given to the author. So without the author or without the creator consent, you can't use it. For example, take any example of music industry. So somebody has created the music composition. If they created the music composition, so that will be protected under the author name. So if you want to use that music for your event and all, so you have to take the permission from the creator. So in India, there is a like structural mechanisms are there. In that structural mechanism, it is protected under the Copyright Act. So this is the copyrighted and also design. Many people will confuse design and patent are both are similar because very extent actually design is something different, patent is something different. So patent is a exclusive right you will be getting for your creation or invention actually. A design is completely connected with the like designing of the modules. So you will be protected your design and like topography kind of things under the Design Act. So under the Design Act, your composition of the design methodology will be protected. So this in the design, the maximum protection period is 10 to 15 years. Initially, it is a 10 years. So later you have to renew for 5 years. The maximum tenure is 15 years. So Design Act 2000, we India about Design Act in 2000 year actually. Then it started implementing in 2001. So it will be extended till now actually. It is a prospective law. So when we compare with the patent and design, it has taken the 30 years period, but still it is one of the important IPR field. And if you go to the geographical indication, this is the one of the new, like it is one of the like very important area. Many people will neglect it. So India bought Geographical Indication Protection Act in 1999. Under this GI Act actually, so we are going to protect our certain products which have like significance and also name from the origin of the place. So take example of Mysore Pak or Mysore Silk or Tirupati Laddu. So these are the things, items, it has some significance from the origin. So the consumer will be getting that reliability and also value for that product. So it will be protect for the producer community. When we compare with the other intellectual property, they are individual oriented, but geographical indication thing is completely connected with the producer community. So it will be very very booming. And also in India, when compared with the other laws, GI law is very limited. It covers agriculture products, non-agriculture products, artistic products. All the products will be covered under the GI. But implement registration procedure also covered actually. But implementation enforcement thing is lacking under GI Act. Similarly, we have traditional knowledge, and also similarly, like this also one part of the intellectual property. But traditional knowledge, we have separate law, but it's not protected under any like mentioned laws. See, as I told here, so we have different intellectual property. So under different intellectual property, I have given some idea insights related to the patent, trademark, copyright, design act, geographical indications. So under this umbrella, each have their own significance and own role. So learning this will be having more beneficial for an like end generations, because as a I'm from the technical background and also I'm from the law background. So I am connecting the technical knowledge and also with the legal knowledge with respect to this IPR field. So it gives immense like opportunities for the young generation to work on, because the future is all about creation. The creation, whatever the creation you do, that creation you want to protect it, because generally we used to like fight for a property, because property will be giving the rights to you. You will be having the exclusive rights over the property. So if you get it, no, if you get this intellectual property rights on like from like in name of you, then you will be protecting that for a certain period of that, and you will be enjoying that rights actually. So indirectly the main objective of this IPR law, or like whatever the under the IPR subdivisional part of the laws, is to the creator has to get a benefit out of it. So whatever the intellectual, your mind, whatever the mind creation you does actually, that has to be recognized, that has to be rewarded for certain years. From that you have to make benefit out of it. So like that. So by saying this, I will be concluding my topic related introduction to the IPR. So this is not a like ending of this introduction, because this is just a insights what I'm giving to this all the broad umbrella of under the intellectual property rights. Still, lot many things to be discussed. So stay with us. So I will be going in deep of every topic. So enjoy the sessions. So we'll clear all the doubts, and also we'll dive with the ocean of the IPL. Thank you.